Welcome to the 32nd meeting in 2025 of the Delegated Powers and Law Reform Committee. I'd like to remind everyone to please switch off or put to silent their mobile phones and other electronic devices. Apologies have been received from Jeremy Balfour, MSP. The first item of business is to decide whether to take item 6 in private. Is the committee content to take this item in private? Yes. Under agenda item number 2, we're considering an instrument subject to the affirmative procedure. No issues have been raised on the Draft Food Safety Act 1990 Amendment Scotland Regulations 2026. Is the committee content with this instrument? Yes. Under agenda item number 3, we're considering instruments subject to the negative procedure. No issues have been raised on SSIs 2025, 299, 334, 335, 337 and 341. Is the committee content with these instruments? Under agenda item number 4, we're considering a document subject to parliamentary control. No issues have been raised on SG 2025-289, the draft Code of Practice, the non-party campaigner campaign expenditure, Scottish Parliamentary Elections, Code of Practice 2025. Is the committee content that no reporting grounds are engaged?
Yes.
In relation to this document, does the committee wish to note that the original draft of this Code of Practice was withdrawn as it appeared that one of the statutory preconditions had not been met, and that the present version has been relayed after the Electoral Commission formally consulted with the Parliament?
Yes. Yep.
Under agenda item number 5, we're taking evidence on the Contract Formation and Remedies Scotland Bill. For our first panel today, I would like to welcome from the Scottish Law Commission, Lady Anne Payton, the Chair, Professor Hector McQueen, the former Lead Commissioner, and Rachel Rayner, the Chief Executive. First of all, I'd like to welcome you all to the committee this morning. And before we start, I'd like to remind you that you don't have to worry about microphones. They'll be dealt with for you. And if you'd like to come in on any question, just please indicate or raise your hand. And there's also no need to answer every question. Just simply indicate that it's not for you to respond to. However, please feel free to follow up in writing for any question after the meeting if you wish. And with that, I'm happy to hand over to Lady Payton to make some opening remarks. Lady Payton.
Thank you very much, and good morning, everyone. It's my privilege as Chair of the Scottish Law Commission to begin this session concerning the Contracts Formation and Remedies Scotland Bill. As you know, the relevant Commission report, which I have here, it was published some years ago, 2018, but we've had the benefit of a new triage procedure created by our sponsors, Jill Clark and Alison Mason. And as a result of this new procedure, the Scottish Government, liaising with the Scottish Law Commission, have carried out a further, more recent consultation exercise. And this is just to check whether there have been any significant changes in the law over the years, or changes in business or attitudes or views over the past few years. So doing a very welcome update. And of course, we've all got the responses from that reconsultation exercise. We're very grateful to Scottish Government for all the work done. And against that background, I now have pleasure in handing over to the former Lead Commissioner in the contract project, Professor Hector McQueen.
Thank you. I don't have anything really to add. I was involved in the triage procedure that Lady Payton's just described. It was a very useful consultation, and it gave an opportunity to think again about the problems which are addressed in this bill, but they didn't raise any issue that suggested that a big change was required at any point.
And Ms. Rayner, is there anything you'd like to add? No? Okay, thank you. So we'll start off with the questioning. And can you explain why legislative reform is needed in this area of law, and what are the advantages and what are the advantages and disadvantages of this reform?
Well, I think the main advantage of statutory reform in general in a common law area is that a common law area may carry various difficulties and issues which just simply don't get resolved because no case comes up in the court in which the matter is addressed. And in between times, while waiting for that decision to arise, there is considerable uncertainty on various points. Now, when we began the exercise of reviewing contract law, I didn't think there would necessarily be all that many issues. The one that was very much uppermost in my mind was the postal acceptance rule. And it wasn't just my mind. The Commission has been recommending the abolition of that rule since the late 60s, in fact. One of the beauties of the Scottish Parliament's availability is that something can actually get done. It was very difficult, I think, pre-devolution to bring these matters up in Westminster. But what the discussion of the postal acceptance rule led on to was consideration of various issues which would need at least clarified in any legislation. It wouldn't be enough just to have a clause or a section saying abolish the postal acceptance rule. You would need to make other issues clear. Primarily, I think, probably the questions of revocation and withdrawal of the communications on either side. And a problem which cropped up in this context was also the question of what the effect of fundamental change of circumstances were during the process of offer and acceptance. The most fundamental of all changes being death of either the person who made the initial offer or of the person to whom the offer was made. But other issues such as the insolvency of these parties were raised. And what was a bit of a discovery, as far as I was concerned, was that there was uncertainty about what the rules were in these circumstances. And it seemed to my team and fellow commissioners at the time that it would be best to be able to cut the Gordian knot and say, here's the rule that you find in the draft bill, and that's an end to the uncertainty. These were the sorts of issues which emerged in the course of the discussion of basically abolishing the postal acceptance rule. And some of the bill is really just about providing the context in which a new regime takes place. It sets out a rule on what is an offer, it sets out a rule on what is an acceptance, and so on. A further issue which I had in mind when starting on the project, and it was starting back in 2009, was the so-called Battle of the Forms. This is the situation which arises when two businesses deal with each other, but each deals on its own standard terms of business. You may well have seen such standard terms of business on the backs of invoices and so on. Now, what frequently happens is that the parties exchange their standard terms of business in the process of contract formation. The two sets of terms don't match. But that doesn't seem really to bother the parties that much. They proceed to perform what is the real substance of the contract. And it's only later, perhaps, that it emerges that because these things don't match, there never was a contract, and the performance which was rendered was therefore not a contractual performance. And that leaves questions of liabilities and so on very much up in the air. Now, we looked at various solutions to this particular issue, but found none of them particularly satisfactory. Where they'd been implemented in other jurisdictions, they didn't seem to work that well. But during the Commission, my period in the Commission, our then chair, Lady Clark of Carlton, decided a case on the Battle of the Forms. And she decided in a very commonsensical way. She said, it doesn't really matter what's in these terms. The parties obviously don't care what's in these terms. They've gone ahead and done a deal. Let's look for the real substance of the deal. Now, we couldn't write that solution, I think, directly into the legislation, but we have at least created the possibility of that solution being applied in future by the provisions near the beginning, defining contract as agreement, and saying that it's not necessary for every single item to be agreed, and that the court can find a contract in these circumstances. And since the report, there's been a further decision in the Court of Session, a very recent decision called Caledonian Water. I think some of the submissions to you mentioned this case. And putting it very straightforwardly, it adopts this approach. It doesn't worry too much about what the standard terms of business may say. What concerns them is the reality, the substantive reality of an agreement between these parties and enforcing it accordingly. So I think our bill leaves that possibility open. It's definitely not saying this is the approach the court must adopt in these cases. It's the approach the court can adopt should it be minded to do so. And I'd be happy to elaborate on that later. Then part two of the bill is essentially about issues in breach of contract. Again, issues which were, I think, very much alive when I was starting my time as a commissioner, and about some of which I wrote as a professor of law in Edinburgh University. The fundamental one was the one that's in, I think, section, let me get my section numbers right, section 17, mutuality of contract. The idea that a party who is in breach of contract cannot sue or enforce the contract so long as they remain in breach. Now, in some ways, that's a very, children's playground sort of rule, but it creates serious difficulties. And during my time at the Commission, there were various cases that came up, mainly in the employment arena. One was called McNeill. The other was a case about a solicitor in Stranraer. Maybe it's worth just talking about the solicitor in Stranraer a little bit as an example of the kind of problems that arise. Now, this solicitor was, I'm afraid to say, one of the bad apples of the solicitor's profession. He'd committed fraud with client money and so on. And his partners in his former firm refused to pay him the pension which he had contributed for many, many years, undoubtedly had contributed the funds to support that pension when his time at the partnership came to an end. And what the court held, by a majority, there was a split in the court, which was always indicative of a degree of uncertainty. The court held that the solicitor couldn't sue his former partners to get his pension because he was in breach of contract by virtue of his fraudulent behaviour with clients' money. Now, the views differ, but on this in terms of the morality of the situation, it's obviously not a very attractive thing to say that this solicitor should get his pension. On the other hand, and this was the argument that impressed me more, he had contributed for many years to this pension fund. He was no longer in practice. He needed his pension to live. And it seemed inappropriate, to me at least, that he should be barred from recovering that pension. So the cases that arose during my time at the Commission reinforced the view which I already held, that there was something wrong with the law if it was really the case that the party in breach could not sue to recover what it was owed. And that's what lies behind Section 17. The scenario, of course, is that both parties are in breach of contract. Now, if you applied the basic rule as it was understood to be, neither of them could sue the other, and you'd be left in a state of suspended animation. And we didn't think that, as I say, was at all appropriate. So we say in Section 17 that a party in breach can claim what is owed to it up until the time that the contract is actually terminated, so that our solicitor in Stranraer would have recovered his pension if this rule was being applied, as I think it would be in that particular case. The second problem was the problem of what's called in the Section 18 the problem of restitution upon rescission. Rescission is a technical term that lawyers use for terminating the contract, basically. But what you often find when a contract is terminated is that there are loose threads hanging. There's been a performance by one party which has not met with its reciprocation from the other side. It's incomplete. Sometimes it's helpful to think of this as the contract has failed. It hasn't gone right through and there are bits left hanging. And what the bill proposes is that the bits left hanging can be restored to put the parties back in the position with regard to these matters that they were in before the performances were rendered. Now, what we found particularly useful here was the work that had been carried out by a group called the Study Group for a European Civil Code, of which I was a member. And what the study group produced was called a draft common frame of reference. It was to help the European Commission with its legislation to have a consistent sort of conceptual basis. And essentially what sections 18 to 21 do is adopt that European instrument. And the basic point of that it's got nothing to do with the European Union as such. There's no obligation whatsoever. But what you had was a team of about 60 experts working out what was the best solution to this problem of failed contracts, which had been terminated. And it was a very well worked out system. I think the point I'd like to stress before I leave that is that it's about uncompleted performances, if you like. It's the unreciprocated bits and no more to which this obligation of restoration or restitution applies. And then the last thing was contributory negligence, which is a well-known concept in the law. And has been since the 19th century and beyond. And again, there's a certain, childhood morality. It's a party in breach says, yes, I was in breach, but the loss that you suffered was not entirely down to that breach. You, the party making the claim at the moment, have some responsibility for the loss that you suffered, contributory negligence, contributing to the loss that was suffered. And in fairness, therefore, the damages which are payable by the contract breaker should be reduced to reflect the amount of the contribution that has been made by the party who is making the claim. Now, this has got bogged down in the UK because of the language of the 1945 Act. And you have this rather curious situation now that there can be a defence of contributory negligence, reducing the pursuing party's damages, if the breach of contract was negligent in breach of a duty to take care, but not otherwise. And this leads to this very paradoxical outcome that the party who is basically defending the action for breach of contract must say, I was negligent, which is a strange thing for someone to say. I was negligent in this breach that I carried out. I broke a duty, and therefore I can plead contributory negligence against the party who is raising the action. And that's the current state of the law, not only in Scotland but also in England and Wales. But to say that it's been controversial is to understate the matter. So what we propose is a simple amendment to the 1945 Act to make it clear that for any breach of contract, not just a negligent breach of contract, it is possible to raise the question of what the contribution to the pursuing party's loss was by that party's own conduct. Otherwise, the law of contributory negligence is left as it stands. The view of the consultees in this was that it worked pretty well most of the time. There was just this odd blip, if you like, with regard to breach of contract. And as you'll see, the bill takes the form of an amendment to the 1945 Act. It's rather a technical sort of amendment. You would probably need to have the 45 Act in front of you in order to see its precise gist, but that is the way our legislative system works. Final point, if I may, Convener, very simple point, important point, I think, for a number of the people sitting behind me. All of this is subject to the parties agreeing otherwise. These are default rules. And in particular, in sophisticated contracting parties will probably have their own regime for almost all these issues. And we are perfectly happy that that regime which they agree should be the one that applies between them. The provisions in this bill are by and large, I think, for less sophisticated parties, parties without legal advice, and I think parties without legal advice will probably be taken by surprise by the postal acceptance rule in particular. But it should be possible for a party reading this bill to have a fair idea of what the law is, to be free of controversies and debates about what the law is, and to arrange their affairs accordingly. Thank you very much.
Okay. Thank you, Mr. Queen. You've obviously covered a great deal of the bill in your opening comments, and clearly some colleagues will come back on some of the issues that you have raised. Just on your final point there regarding the parties without legal advice, do you actually think the bill makes the law clearer, more certain and also more accessible for the wider population?
Yeah. No, I do. I mean, I fully accept that laypersons without legal advice may find legislation in general difficult. And I think it is a question as to how you make legislation sufficiently simple and accessible for it to be readable by the person in the street. And I read the comments from the Scottish Motor Trade Association, who could probably be regarded as a fairly sophisticated user, to the effect that couldn't understand it at all. Now, I think in fairness to us, the drafters of the bill, the thing that they seek is precision, so that it is crystal clear ultimately to a court what the answer should be. To my mind, the most important group of all are the advisors. My great hope would be that this bill, provisions of this bill, never come into court, because it's been possible for legal advisors to say this is the result that follows from these words that have been used, and that's the outcome, and disputes would get settled best that way. So I don't have any doubt that people with legal advice will be able to handle this bill. I think it's very clearly expressed. I think what I would say to the whoever wrote the SMTA thing is that perhaps you should come and take one of my MBA courses at Edinburgh University, or one of my construction law courses at Edinburgh University, because amongst the most enjoyable teaching that I ever did in my university days was teaching people who were professionals or working in other fields. And what I was always asked to do was contract law, and I did my best to explain it. And the enthusiasm and on the whole understanding, it wasn't always completely clear, was abundantly plain to me. And indeed, one particular student whom I remember saying, "It's so beautiful," which was music to my ears, because I think it's beautiful. But it is about taking the steps that you need to get into, as it were, the lawyer's groove, the thinking that underpins these bits of legislation that we're looking at. And I would hope that for people like that, it is possible to read this bill and to see what the rules are on the particular areas dealt with. We did our best, let's put it that way.
Thank you. I think just for clarity, obviously other universities are available, and other courses are available too.
No, actually, I did some of my teaching in construction law in Strathclyde University, so there, no, I have no particular axe to grind in that score.
Do you have a view on the arguments made by Dr. Jonathan Brown of Strathclyde University in response to our call for views that the existing common law and contract does not need any reform, or that any reform should have a wider ambit, taking into account other aspects of Scots private law?
Well, I have several things. I have a written paper which I can send to the committee, but it's 3 pages long, so I won't read it out to you and take up your time. I have the greatest respect for Jonathan Brown. He's a good friend of mine, and he's sitting in this room just now, so I'm very conscious of that behind me. But I do think his concerns are misplaced. I mean, I would start with the postal acceptance rule. That was really where the exercise began for me. I wouldn't accept that the postal acceptance rule is intuitive, or one that the person in the street immediately thinks of as the contract rule. Because what the postal acceptance rule means, putting it very simply, is if an acceptance is posted, then from the moment of posting there's a contract. It doesn't matter whether the addressee of that acceptance, the offeror, knows about it. All that matters is that the thing was posted. And I think that is, to say that it forms a contract is counterintuitive. And the reality of practice for decades, if not centuries, has been that when parties are setting up a contractual negotiation with professional advice, then they will exclude the postal acceptance rule. It'll be some sort of statement such as, your acceptance must reach us usually by such and such a date, and so on and so forth. So I don't think it's intuitive, the postal acceptance rule, and I think it's commonly excluded by those who know about it. And that means that the only people who are not going to be, the only people who won't exclude the postal acceptance rule are liable to be taken by surprise by the fact that they were in a contract when they didn't know about it. And it's still a matter of dispute whether, if the acceptance letter is lost in the post, it nonetheless binds the party. And the courts have from time to time indicated that there are circumstances in which they wouldn't apply the postal acceptance rule in its full rigour, and I can go into that if needed. But the thing I would stress then is that that's where we began with our efforts in this area, and that all the rest on offer and acceptance is really driven by a need to clarify what the position is after that rule has been got rid of. There's so much focus on the postal acceptance rule that sometimes the underlying principles are overlooked. Now, I think what Dr. Brown argues in his note is that the postal acceptance rule wasn't really the exception to the general rule in which parties must communicate with each other in order to bind each other in a contract. And what I think I would say, and I do differ from Dr. Brown on this point, is that what he is putting forward as the common law may have been the law before, at latest, 1855. But since 1855, in a case called Thompson against James, it has been quite clear that it is not the law that when the parties have each, as it were, emitted a signal saying, I like this contract, without necessarily communicating with each other, that there is a contract. Now, that was possibly the rule, as I say, until 1855, but there was a decisive departure from it in the case of Thompson against James in 1855. And that departure was recognised and is still recognised in all the books, textbooks and so on contract law. Communication is key to the offer acceptance process working, except for the postal acceptance rule. So that's my disagreement at root. I fully accept that there are other legally binding statements which do not necessarily need communication to the party to benefit from them. Unilateral promises are the prime example, but the bill carefully saves unilateral promises law in section, let me get this right, 4.3. And it's also worth noting, just with regard to the general availability of the common law, the law as it exists at this moment in time, there's a saving for that as well in section 23A, so that if there are any questions which this bill does not address, then the common law continues to apply. And it's worth noting, I think, that it's the common law that will still say that an offer met by an acceptance is a contract. Okay, that's nowhere said in this bill. And when I tackled the draftsman about what we need to say, he said it's not a code. If it was a code, it would have to be complete. But it is sufficient, given the existing state of the common law, to clarify how the law defines offers and acceptances. And it's obvious from the bill that offer and acceptance are what constitute or what can constitute a contract. So it's not the case that the bill sweeps everything that's gone before away. The other point I'd like to make is, and I'm sure Dr. Brown will have things to say, he makes quite a lot in his submission to you of an article that was published in 2018 in the Scots Law Times, which is a very interesting article indeed about the rights of disabled people and the question of when, particularly those with mental health problems, when their wishes should be respected. It's a very interesting discussion of that particular issue. And one of the authors is a well-known lawyer in the disability field, Adrian Ward. I'm sure he's probably appeared before this committee or some other committee in this Parliament on previous occasions. And it is definitely an interesting article because what he's pointing out with his co-author is that there's a convention on the rights of on the rights of disabled persons which says not just respect, but actually give effect to the wishes of the disabled person as far as possible. And the question which the article addresses primarily is, okay, in what circumstances should we give effect, not just respect, but give effect to the wishes of the disabled person, and in what circumstances can these wishes be overridden? And it appears from the article that one of the things that had been discussed with the People First group, which is a group of disabled people who are wishing to improve the way in which disabled people are treated and handled. They put before them the famous test from Stair's institutions. What is a definitive committing act of the will? And there's desire, which is forming, yes, I'd like to do this. Resolution, yes, I am going to do this. And then engagement, when you commit to doing it. And it appears from the article that the People First group could appreciate these differentiations and could say that engagement was the point at which they would wish their wishes not just to be respected, but given effect to. But they recognised that there were still problems. Now, you would have to read the article to go through it all, but they in fact add a fourth stage, which is a certain, meaning definitely it's going to happen, future will. So desire, resolution, engagement isn't everything. And what I think is, this is a very interesting article, and I commend it to anyone who wants to follow it through. But it's not really about the formation of contracts. It's a completely different subject. And there is nothing in this bill that prevents people reading Stair's institutions, should they be so minded. In fact, I refer to this passage of desire, resolution, engagement in my own textbook. And I know that in the event of this bill being passed, my textbook will continue to refer to it. The article also refers to decisions of the German Federal Constitutional Court. And obviously there's nothing in the bill to prevent that. So what I would dispute, really, in Dr. Brown's analysis is that this is evidence that the common law is somehow tied into intuitions, general intuitions about what makes a contract. The whole question in the article is really dealing with a very important, but definitely a different area than the law on the formation of contract.
Thank you, Professor McQueen. I'm going to have to ask just for shorter responses, please.
I usually speak for 50 minutes.
So we do have obviously the second panel after
Yes, sure.
this panel. Yeah. And so the final question for me at the moment is that some of the proposals for the reform of contract law were made in the 1990s or even earlier, as has been highlighted. Do you know why it took so long for the proposed reforms to lead to a bill? And do you think anything could be done to speed up the pace of reform in the future?
Yes, as I think I hinted in my earlier remarks, I think a crucial development is actually the institution of the Scottish Parliament in 1999. Most of the previous reports on contract matters were in the 90s, 80s, or even earlier. And getting time at Westminster, as actually is also the case here at Holyrood, is problematic. And you know, there would be a tendency, I think, in Whitehall to favour a uniform reform of the law on, for example, postal acceptances. If there was to be a reform, it had better be one for the whole UK. So we're not trammelled by that. And we have this procedure before the DPLRC, which I've now experiencing for the third time. And that transforms things. I really do think that's been a major development, and I very much hope it continues into the future, whatever the fate of this bill might be.
As a committee, we actually enjoy doing this type of work. So it's a welcome change.
Yes.
From all the secondary legislation that we usually look at.
Yeah.
So I'm going to hand over to Ros McCall.
Thank you, Convener, and good morning, panel. Thank you very much for coming along. Professor McQueen, can you explain why the decision was made to only reform the law on formation of contract and certain aspects of the law of remedies for breach of contract instead of contract law in word generally?
Yes, there's a long history here, and I will try not to go into it. But back in the day, in the 60s, when the commissions were in Scotland and England were first set up, there was a project to have a UK contract code. Now, that failed after 7 years of very hard work. They didn't get to the end result that they hoped for. And I think ever since that, both law commissions have been wary of overly ambitious codes in general. It's desirable for the purposes of knowing what the law is. I think there's a case for it across the board. But a code that covered the whole of Scottish private law, or even the whole of Scottish contract law, would take up an awful lot of this Parliament's time. And it would be probably contentious at various areas. So the Commission's, Scottish Commission in particular, has always been, in my experience, cautious, one step at a time. I hate to say it, but in the interests of the Parliament, as much as anything, but also our own interests, because the kind of work you're suggesting would take a massive effort. And most commissioners are only there for 5 to 8 years, and they do have other things to do with their lives. I know there was a huge disappointment with the UK. I happen to have been investigating it for academic purposes, and it really was a disaster when it fell apart in 1973. So I think it's one step at a time, small steps, and eventually perhaps you'll get there.
Okay, that's very interesting. So what's your view of the Law Society's response to the committee's call for views that only dealing with certain remedies for breach of contract in the bill could lead to fragmentation and legal uncertainties in the long term?
Yes, I would very much hope that's not the case, that one is simply intervening, as I tried to explain in my opening remarks, in areas where there has definitely been a difficulty. It's quite clear there is uncertainty and problems for advisors as much as anyone else. Beyond that, yes, we did review the whole area in my exercise, but it was never the intent that this exercise should lead to a comprehensive statutory statement in that particular area. Even the formation is not a comprehensive statement. We were trying to solve real problems that we had identified. Now, since the report in 2018, we have identified, with the aid of the Scottish Government, a problem in another area related to breach of contract. That's the amendment on retention, which will come up. So that will be addressed, provided the amendment is passed. But other areas like damages, for example, huge subject and very problematic.
Excellent. So that's really interesting. So given that the idea is to look at this on a sort of smaller is slightly better in reform way, is there any plans, or can you outline any plans that the Commission has for further reform of contract law, maybe in the future?
I can't say anything at the present time, okay. But what I can say, and Lady Payton will correct me if I go wrong, or indeed Rachel Rayner here, next year the Commission will be consulting on its next programme of work. And my appointment followed a similar consultation and the proposal that there be a review of contract law. I certainly read all these comments with great interest, and I would intend in submitting to the Commission consultation on its programme. We could do more work on contracts. Okay. It won't be me, but it will be worth doing, and especially if the Law Society thinks so.
Okay, thank you, and thank you, Convener.
Thank you, and Bill Kidd.
Yes, thank you, Convener. Now, I think it's already been very well covered in terms of about abolition of the postal acceptance rule, so I don't think we need to cover that again. But following on from that, in a way, is it possible to explain how the bill seeks to deal with contracts formed electronically, which I presume is the natural sort of superseding, and what's the view on the Law Society's argument in its response to the call for views that it's not clear how the rules on notification by electronic means in Section 13 will apply when someone has an out-of-office message on, or where messaging servers aren't working at all?
Yes, it's a good question and an important point. Thank you. Basically, if I need to check the precise wording of the bill and in which section it appears, but I think the Section 13, subsection 3, covers it. Undoubtedly, all the rules that we are talking about will apply to electronic communications. And I mean, another of the benefits, if you will, of the bill is that it makes clear when an electronic communication is to be regarded as reaching the other side. But the crucial thing in Section 13.3 is that a notification, an email or whatever it might be, reaches a person, let's say becomes effective, when it is made available to the person who is the addressee in such circumstances as make it reasonable to expect that person to be able to obtain access to it without reasonable delay. Now, in our report, we talk about the out of office as an indication that it would not be reasonable to think that this person will immediately be able to access this communication. I'm on holiday, or whatever it might be. That's one of the facts and circumstances to consider with regard to reasonableness. We were chary of making explicit references because it's all too familiar, to me at least, to have out-of-office messages that haven't been switched off when the person in question returned to the office. I remember one from a dear friend in Aberdeen who was out of office for September, whatever it was, and he was still out of office for September come the following January. So not very efficient. So we were a bit wary about making explicit reference to out-of-office messages and the like. But we did have this provision about reasonableness, and reasonableness would certainly, I think, encompass the fact that an immediate return was an out-of-office message. So I think we have covered that base. I did notice what the Law Society said, but I've scribbled in the margins, that's okay.
Well, just on the back of that, though, sometimes it might not be out of office as such, but even here in the Scottish Parliament just a couple of weeks ago, we had to bring everything in the chamber to a halt because Microsoft gave up somehow in Japan and America and here and all that.
Yes.
And so everything collapsed effectively. And how would that come into force then? Is that very similar to out of office, or would that
I think so. I mean, in such circumstances as make it reasonable, obviously there are questions of proof of date of sending, time of sending, and so on. But these are actually quite easily achieved by virtue of the fact that in the sent box there are the necessary details. So I think the generality of Section 13.3 in this regard should cover most conceivable bases. And I mean, one of the things, again, in the Commission and in the drafting of the bill is you don't want to be too specific, because inevitably there'll be a gap in the middle. So having a general provision like this for the kinds of circumstance we're talking about here is preferable. And if a dispute breaks out, then we leave it to the judge ultimately to decide what is reasonable. And that's the judge's job, if I may say so, to take these kinds of decisions.
And if it is too specific, then it leaves nothing for lawyers to argue with each other about anyway.
Well, possibly. They can still argue happily about what's reasonable.
I'm a bit fluent, Richard. Sorry, but thank you very much.
Thank you.
Thank you. Ross McCall.
And hello again. You explained very well in your opening submission the information on the current problems around the Battle of the Forums, and I appreciate that, so I'm not going to go into that again. And equally, another one of my questions was based on the sort of breach of contract, which again, in your opening submission, you covered very well. But what are your views of arguments made in response to the call for views that guidance will be needed on legislation, for example, on how the new rules interact with areas of contract law which remain governed by the common law?
Yeah. Well, I would hope that it would not be too difficult, because the slots that we're looking at are fairly readily identifiable in the present law, and one simply puts this new unit, as it were, into place. Yes, I'm sure there will be training and familiarisation required, and people like me are very happy to provide it. Actually, I don't really do it anymore, but colleagues behind me, I'm sure all of them from universities are well accustomed to delivering update courses or things of that kind. So I don't think there'll be great difficulty. I'm encouraged by the fact that so many submissions seem to recognise that this is not a radical change that requires rethinking of everything one had ever previously thought about contract law. It just clarifies.
Yeah, that's excellent. Thank you, and thank you, Convener.
Okay, thank you. And Katie Clark.
Can you explain whether the new rules on contract law will only apply to contracts entered into after the bill comes in force?
I can't as such, because that's not my responsibility. What will happen if I have got it right, and I could be corrected if I go wrong here, is that this bill will be brought into, if it passes the Parliament, will be brought into force by statutory instrument. And the statutory instrument will spell out what the transition provisions are. Now, I think the answer is reasonably obvious, but I'm a simple professor, not a parliamentary draftsperson. And the answer is it should only apply to contracts that are in process of formation after whatever date is chosen, and likewise with the breach of contract provisions. But that's in the hands of either the parliamentary draftsman or the Scottish Government lawyers who draft the.
So your presumption is it wouldn't apply to pre-existing
No, definitely
contracts?
not. I'm not strongly against that sort of thing.
Thank you. And what's your view of the Scottish Government's proposals to amend the law of retention at stage 2?
Yes, well, I'm a fairly unqualified supporter, because I was heavily involved in the consultation which preceded the production of this amendment. I mean, we did think in the Commission 2018 of putting in provisions on the law of retention, because we did think it was a bit of a mess. What we thought was that by setting out in the report that it was a mess, that it would get picked up in the courts, and the courts would then make their statement. Unfortunately, the case that was decided almost immediately after I left the Commission, Lamont against Heathfield, showed division of view. There were 3 different judgments. They all reached the same result, but by different routes. And it was at that point that I thought, we cannot depend on the courts to pick up the clear messages from the Commission. We have to bring it forward as legislation. And I was delighted when the Scottish Government proved amenable to that proposition. My colleague Lorna Richardson, who will be giving evidence the next session, is probably the principal inspiration behind the bill, so I'm sure she'll be able to answer questions more fully than I can.
Thank you. And what is your view about the responses to the committee's call for views about the right to contract out of any new rules on the law of retention? Is that something you've considered?
I would support that. It's possibly something that should have been made clearer in the bill, but in the amendment itself. But this part 2 of the bill has its opening as everything is subject to the parties' agreement, and that's what I would say. I mean, the one thing that I think parties will have to think about is how clearly do you have to exclude this statutory provision. There's been a bit of unclarity about how you exclude the law of retention at common law. Nobody doubts it's possible, but some of the attempts to do so have foundered when it got into court. So, yeah, the onus will be on the drafters of contracts to be clear about what they want. But otherwise, no, I have no problems with subjecting the provision to the regime that applies to all the rest.
Thank you. And are there any other comments on the bill or any other arguments or drafting suggestions made in responses to the call for views that the committee received that you think are worth highlighting or that you would support?
Yes, I think it's certainly worth considering. I've already submitted 3 suggestions to the Scottish Government team, and having read now the submissions, yes, there are 1 or 2 that I would like time to think about, but they're on the whole fairly minor. For example, in section, is it 4, changing proposer to offeror. Yeah, I can see that that might be helpful, but these things need discussion and testing.
So there's quite a few suggestions of changing the terms.
Yeah, sure.
And that's something you're in favour of. I know there will be.
Well, I'm open to it. I mean, I've got a lot of notes down the margins of the printout of the submission saying no or maybe or question mark. So for discussion, the crucial thing is that they're helpful to the bill.
Okay, thank you.
Thank you. Just following on from Katie Clark's question, one of those suggestions was from Sirko Harder of the University of Sussex.
Yes.
When he argues that the term rescission in the bill should be replaced by termination, as this would make Scots contract law more accessible to the international business community. And I know that certainly was one of the aspects about this committee having the remit extended to cover SLC bills, to obviously help the Scottish economy and make the business community, make Scotland more open and welcoming to the business community.
No, absolutely, and perhaps I should have said that in my opening remarks, because if you read the BRIA to the report, you'll see this is set out at the very beginning. There was a Scottish business law experts group making recommendations in 2008. Yes, I would favour termination ahead of rescission. Rescission is there because that's a term that lawyers are familiar with, right? But in the more ambitious moments of the project, we did talk about trying to change terminology. And had we dealt with rescission, we might have used the terminology of termination in its place. But in the end, what we have is a bill which has reformed certain areas, and it wasn't really possible to tack onto that a comprehensive reform of terminology to bring it up to date. It's the sort of thing that might well be done if there was a further exercise on the review of contract law. But for the moment, it's not really possible, I think, with this particular type of bill that we have in front of us. With retention, we had a notion of suspension or withholding performance. And that kind of language appears in the substantive text, but we don't seek to change the terminology, the technical term for the particular area. And by not changing the technical term, we obviously emphasise the continuity, which was the subject of Ms. Clark's question earlier on. But yes, in my ideal world, it would be termination, but we're not quite in an ideal world yet.
Okay, well, thank you. If any colleagues have any further questions? Okay, thank you. And I'd like to thank you all for your evidence this morning. And also I'm aware certainly was Professor McQueen, you're going to send over that paper.
Yes, I can do that. That's no problem. Do I send it to the clerk?
Yes, thank you. Yes. And certainly, obviously, we may have some further questions afterwards. So certainly, thank you very much for your evidence. And I will now suspend the meeting briefly to allow a change of the panel. Thank you.
Could I just thank you, committee, for giving us this opportunity to contribute to the debate. And it's been a pleasure taking part in your proceedings. Thank you.
Okay. Thank you very much, and I'll now briefly suspend. Welcome to the committee. And we're actually quite a friendly bunch, as you'll have picked up this morning. So, my wife has got the head cold. Certainly. Okay, is everyone ready? Okay. Okay, yeah. Okay. For our second panel today, I'd like to welcome Lorna Richardson, the Senior Lecturer, University of Edinburgh, Dr David Christie, the Associate Dean for Academic Development and Student Experience at Robert Gordon University, Dr Jonathan Brown, the Lecturer in Scots Private Law at the University of Strathclyde, Professor Stephen Bogle, Professor of Law and Interpersonal Justice at the University of Glasgow, and Dr Hamish Patrick, the member of the Banking Company and Insolvency Subcommittee of the Law Society of Scotland. I welcome you all to the meeting, and once again, before we do start, please you don't need to press any buttons, that will all be sorted out for you, and if you do want to come in on any question, please just raise your hand or indicate, and also there is no need to answer every single question if you don't feel as if it's for you. So with that, we'll just move straight to questions. So, first of all, can you set out your experiences as regards to contract formation and give the committee some examples of how contracts are formed in different sectors, for example, in relation to construction, financial services, etc. And we'll start with Dr Patrick.
Yes, I'm a solicitor in private practice with Shepherd Wedderburn, and I'm a finance lawyer, so therefore a lot of my experience has been in relation to financial sector contracts of one sort or another for over 30 years. And obviously there's a whole spread of different types of contracts that people enter into from the retail consumer customer level up to the more sophisticated, complicated contracts that large businesses, government bodies, and all the rest of it enter into with each other. For a lot of the more sophisticated level of contracts, a lot of what is in the bill will be contracted out of, in effect, because, for example, most commercial contracts are not formed by offer and acceptance at all. They're offered by they're formed by means of a written contract signed by both parties. The contract itself will not come into effect until there is very normally something like an agreed effective time concept. Everyone will sit in a conference call or a Teams call and agree that things will all go live now. Nothing will go live until everything goes live. So various parts of the bill at the more sophisticated level just won't happen that way. Some of the online stuff likewise as well. You will have framework agreements under which contracts will be formed under a given system. The various online trading platforms, for example, you will have a framework agreement entered into in one of those sorts of ways, and then you will enter into transactions under that framework by means of a mechanism set up. You will click or something like that. And we've had some discussion already about what is an acceptance when you've emailed it. Well, will clicking I accept be the same? And I think I agree with Professor McQueen in that it kind of will be. So there's a whole broad expanse of different sorts of contracts. Similarly, in terms of remedies, retention, and so forth, at the more sophisticated level. Actually, in terms of less sophisticated level, I think at the less sophisticated level, the bill, I think, sets out. It clarifies what's there already. It changes some things in a manner which makes them more predictable for normal users. So I think for small businesses and for individuals in their personal lives, it's going to work probably as they would predict without having to read it and understand it. So I think a lot of the result sort of works. For a lot of commercial situations, it sort of works as well. At the more sophisticated level, there will be a lot of detail. For example, on the retention, the rescission, and so forth, there will be lots of events rather than breaches. You will have termination events, you will have events of default, you will have a whole series of things that can happen, which may or may not be a breach of contract, which may or may not have a given event. And it's something which I think people must bear in mind, that it's not always straightforward to say that something is a breach of contract or not a breach of contract. Almost every breach of contract can be rewritten as an option or a termination event. I will get planning permission in order to have this development go ahead. I have not got planning permission, I'm in breach of contract. Or this development will not go ahead unless the condition of the obtaining of planning permission has been obtained. So all of these things are in the larger commercial context a bit more complicated. It's not simply breach. And I'd be interested in comments of others at some point about things like rescission and termination, because I may have got this wrong from the old days. You rescinded a contract for breach, and if there's not a breach, then you're terminated as a consequence of an option or a right to terminate. So I think we have to think about all of these things. And in sophisticated contracts, the various consequences of breach termination event will be set out in copious detail. There will be various variants depending upon the situation, who is in breach. At the moment, the issue regarding Section 17 and not being able to do stuff because both people are in breach doesn't happen in sophisticated contracts. You look at the International Swaps and Derivatives Association standard agreement for derivatives and swaps. It's got huge amounts of detail on what happens in all of these different situations. When one party is in breach, when both parties are in breach, when both parties are in breach or not in breach for a given reason, is an event, a force majeure event, a breach or not. So anyway, what I'm saying is that there's a whole spread of different sorts of things, and the most critical point from my perspective is that it can be contracted out of. I think that's absolutely critical from the large commercial level.
Okay, thank you, Dr. Patrick. Does anyone else want to deal with that first question? Yeah, sure.
Thank the committee for inviting me along this morning. One of the things that I think needs to be emphasised is that a lot of what's here isn't going to affect sophisticated commercial parties, whether that's in construction industry or financial services or in other areas where there's high value transactions and parties have control of the formation of the contract themselves. I think what really helps here is that you've got default provisions which will help small and medium-sized companies. And the key thing here is that the provisions actually are based on very solid principles of Scots contract law, but also they're common sense. Of course, the legislation is not articulated in a language that you would want to talk to your friends in the pub in, but the basic underlying law here that will hopefully go through is really basic understanding. And Hector spoke about kind of school ground morality, but what we're doing here, hopefully, is very basic so that parties aren't surprised. If they do not have the benefit of legal advice, they won't be surprised at the outcome of the default rules. And the other thing I would say, just to answer your question, is that although I haven't practiced for 15 years, partly because my research notes in private practice were too long, I have researched this area for 15 years. And what the Commission has proposed here is something that wouldn't surprise people in the international community. What they did over a period of 10 years or longer is look at commercial instruments that reflect standard operating practices of large organisations or just generally conventional way by which people contract internationally. And what we've got here is something that wouldn't surprise people out with Scotland is what we're doing here with this. It's very modern, very common sense way of doing things. So that's what I would add to that. And if you ask about in practice, and I'll leave it here, is I might go out of, stick my neck out here and say, I think we've got a problem in Scotland in terms of the volume of case law that goes through, particularly the Court of Session. I don't think we have enough case law to give the lifeblood to a common law system. I'll not go into the statistics here, but there is a lack of decisions coming out that give that regular certainty of what the principles are. The principles are clear, and academics like I can tell you what they are, but in order for business community to feel certain they need regular cases, and I don't think we have enough in Scotland. So this proposal that's on the table here is a really beneficial thing for the Scottish economy, and it sends out a really clear signal. We're modernising. You don't need to wait around for 4 appeal cases a year, because in England and Wales you'll get maybe 100 cases that might touch on it. So, or I think about 80 in the Court of Appeal to 4 that you get in Scotland from the Inner House, and it's not enough. So what this legislation will hopefully do is give that certainty, and it won't surprise anyone.
Thank you, Professor Bogle. So that's obviously stimulated others in the panel, which I will bring in a moment. But just your final point there, that clearly was a message that came up in the written submissions that we have before us today. I think it was Dr. Christie. I think you had your indicated first.
Convener, I suppose I come at this from a construction law perspective, and I think just to differentiate that or qualify why that is relevant here, I think at the top end, as Professor Bogle and Dr. Patrick have said, big construction contracts will be technical commercial contracts, but when you get to residential construction, that I think is probably the real fulcrum for testing these reforms, because that's the arena in which you will have lay people contracting with small and medium-sized enterprises. They may have written terms of contract, but they won't necessarily be that sophisticated. And they're at that region where the economy of going to litigation is marginal. So if you have an extension built on your house, what's that? Depending on which part of the country you live in, but it will be around about the point which is uneconomic to sue if it goes all horribly wrong. So in which case you need to have clarity in your contract so you can make it work and you can keep the relationship going rather than having to go to court. And I think one of the questions is about the workability of these reforms is clarity. And I know it sounds like the committee have been very concerned about clarity. And I suppose one of the basic points is this always going to be clear to the layperson? Maybe not. Is it clearer than going through even Professor McQueen's excellent textbook? Yes.
Thank you. Yes.
Join in by saying that unlike Drs Patrick and Christie and indeed Professor Bogle, I've not been a practitioner, so I lack that experience. I'm more of a thoroughbred academic here. But I'm in, I think, complete agreement with what Dr Patrick has said in respect of the central thrust of this useful element of the bill being allowing for contracting out of its provisions, because fundamentally in sophisticated contracts this really isn't going to govern the rules of the game. Party autonomy is, and I think that is crucial. I think that's extremely important. I am in more disagreement with Dr Christie and Professor Bogle in respect of whether or not this legislation is actually appropriate in the kind of form that it's taking, as I think will be clear from my submission. But more than that, although a lot of people are going to be thinking about this in terms of how this is going to affect the economy, how this is going to be affecting businesses at a kind of higher level. I mean, you asked at the immediate point about explaining really what contracts are, what contracts happen to be. Dr Patrick alluded to the fact that if you bought a can of Coke on your way into work this morning, you entered into a binding consumer contract. That's not something that the man in the street would intuitively regard as being a contract, but a contract it is nonetheless. And an altogether more unusual example, albeit a very well-known one to legal academics, is the case of Robertson against Anderson from 2003, in which 2 women who attended the bingo agreed with one another that they would split the prize money if one of them happened to win it. Lo and behold, one of them did win it, and the other came calling for the money. And safe to say they're not friends anymore, because this wound up litigating all the way up to the Court of Session, where it was ultimately held that although there's no commercial dimension to this at all, this is a binding contract. It is, as Professor McQueen quite eloquently put it, a kind of playground morality that goes to the very root of the Scottish legal system. Agreements must be kept. do what you say that you're going to do. And where I'm in disagreement with Professor Bogle about the utility of this legislation is really, I take his point that England has the advantage of a great deal of litigation with a great many cases that are deciding new matters as they come up. And if we're going to look at the common law of Scotland as driven entirely by case law, we would appear to be at a disadvantage. It is certainly the case, as Professor Reid in a Festschrift a number of years ago recognised, that the engine of the Scottish mixed legal system has very much been driven by a kind of big C common law case-based approach. But it is still a mixed legal system, and that has, I think, two consequences. The first being that we can and should be relying more on learned writings on the law. There are very many good academic works out there that do debate and clarify the law in a way that is not prescriptive, in a way that allows for the courts to do what Lady Carmichael did and say, well, here's common sense. Here's how we can resolve this issue without recourse to prescriptive law telling us this is what must be done. Because as Professor McQueen says, you can't legislate, just use common sense. But the courts can, in the absence of legislation, just apply common sense. And so I would disagree with Professor Bogle that the lack of cases is a bad thing in Scotland. I think the lack of cases, on the one hand, isn't as much of a problem as it may seem. More than that, the lack of cases is possibly indicative of what I certainly believe to be the case. And that is that the law, the common law as it stands, is working quite well. Because you only get litigation when things are going wrong. You only get litigation where there is disagreement. And if there is limited litigation, that is indicative of there being little uncertainty. As Lord Monboddo pointed out, points that have never been decided are probably the most certain in our law. So that would be kind of my opening salvo, as it were.
Okay, no, thank you, Dr Brown and Lorna Richardson.
By my colleagues on the panel, the bill itself and the commercial parties who are well advised contracting out of it is what currently happens. So the bill doesn't make any change to the way that parties who have the benefit of legal advice or who are complex commercial entities operate. That is the case at the moment, and as has been indicated, it's important for practitioners to feel that they can make their own rules, and as Professor McQueen said in the last session, that is something that the bill allows to happen in almost all instances. Complex commercial contracts, though, do sometimes end up in court. There are a number of reasons for that. One, you cannot simply deal with every situation that might arise, and so in relation to certain parts of the law of contract, some of which are covered in the bill, we still see parties who have complex contracts, who have been legally advised by magic circle law firms, ending up in court. So I think that there is a place for these rules as a backup, as a set of default rules that are available to parties should they need to use them. I just want to reiterate the point also made by some of my colleagues on the panel that the law might not necessarily be clear and precise, and you look at your facts and you can say the outcome is X if you're not a lawyer. I don't think that's going to be possible, but the law is certainly, in terms of the bill, much clearer than it is at the moment. At the moment, if you need to understand how a contract is formed, you at the very least need to be able to buy a textbook. You need to know which textbook to buy. You need to know what the terminology means. There's a problem in people getting access to those materials, not just understanding those materials, but being able to access those materials. So I think that the bill, together with the explanatory notes, will go quite some way to someone looking to understand, at least at a basic level, what their rights are, whether a contract has been formed, etc. I think it goes quite some way there. And just to pick up on Dr Brown's last point, I don't think we don't have litigation because things are clear. I think we don't have litigation because it's expensive. It takes a long time and it costs a lot of money, and unless you have that and unless the claim is worth it to you, you simply are not going to take those steps and take those risks.
Okay, no, thank you. That's a very helpful answer. It does take me on to kind of the question 2 area, which you've answered very clearly. So, just in terms of the forum the proposed reform that we have in front of us. Do you think that this is actually necessary? And with regards to the clarity and the transparency and also the certainty, do you think that the bill accomplishes that? Obviously, so Ms Richardson clearly highlighted her comments a moment ago.
I think it does. It clarifies certain parts of the law. As Professor McQueen said in the last session, it's not a code, it's not comprehensive, it doesn't look to cover everything, but it picks on those areas that were highlighted during the Law Commission's work and the responses to their consultations, the areas that were causing some difficulty, the areas where there was real doubt, and so it clarifies those areas. It sets out in clearer terms, I think, issues that have been difficult, again, with the lack of cases going to court. What happens with emails? Are emails subject to the postal acceptance rule? Why should they be? Why shouldn't they be? Well, you know, they're not instantaneous. There is a delay, so in that respect, they are like the post, but they're not the post. So that these have been issues that have not been clarified in Scots law. They have to some extent in English law, but at very low levels, the cases at first instance. So I think in terms of what's proposed, it's looking to deal with issues that are tricky, that have been unclear, and the way in which the law is set out is as accessible as it maybe is possible to make the law without trying to go into absolutely every sort of situation, which is not possible in terms of legislation, to set out for those who are minded to try to understand it. I think that someone without a legal background would be able to, with a bit of work, get there. Also, the rules are there not just for now, the rules are there hopefully for some time, and so we see now not just emails, but we see sort of platforms, apps being used to enter into contracts, and so if the rules are very, very specific, they become outdated very quickly, and that's not ideal. So I think in terms of a balance between what we need to change, what's been unclear, postal acceptance has been a tricky rule for quite some time. It doesn't fit well with the way we deal with other types of communications in terms of entering into contract. An offer that doesn't reach the offeree has no legal effect. The postal acceptance rule is the one situation where something that doesn't make it to the other party can have an effect, and so it's clear about what it's seeking to achieve, and it does that in a targeted fashion, and I think it's as clear in its terms as it maybe can hope to be in terms of legislation that will cover a wide variety of contracts.
Okay, no, thank you for that. I mean, you just came up with a comment which we heard in the previous session as well, and that's about the legislating for every eventuality. And I think it's fair to say that if going through the COVID experience did prove anything, that parliaments, doesn't matter who's in power, but parliaments cannot legislate for every single eventuality. That became crystal clear very early. Okay, Dr. Christie.
Just to pick up, I think, on points have already been made by Lorna and Dr. Patrick, and the way that technology is changing, you know, this reform is helping to future-proof the law. The dynamic of offer and acceptance is what's used, and reflecting this morning about that terminology, I think we have to, because that's what the law understands, is the idea of offer, counter-offer, acceptance. But that's not really how many commercial contracts are formed nowadays. We saw in the recent House decision, Battle of the Forms, where people were basically emailing each other their standard forms and conditions, but nobody was really paying attention. You know, 30 years ago, you wouldn't be able to generate a multi-page offer, you know, set of terms and conditions and accidentally send it, because it would take so much time and effort to send it that you would obviously have a degree of intentionality. That's changing. You have cloud-based negotiation where everyone's on the same document at the same time. You have social media, WhatsApp communications. They've been held that they can form contracts. So the way in which technology is speeding up communication is really relevant to how contracts are formed. And I'm very conscious that Professor Bogle wrote the book on Enlightenment values and contract. So what we're doing is taking something that takes the best of those values but applies them to a modern way of communicating, and I think that's what this Act helps to do. We discussed at the end of the session with Professor McQueen, you know, is there need to come back and reform? I think we need to keep an eye. I think the way that AI might change intention and parties' intention, the concerns that Dr. Brown has not yet, one day. The concerns that Dr. Brown has about intention and parties in other forms of voluntary obligation, I think they might need a broader look when AI really gets going, because at what point do people's intentions become subverted by generative AI? But we're not there yet. We have to deal with the best guess we can have at the moment, and I think that's what this reform is trying to do, get the law future-proofed.
Okay, no, thank you. And Dr. Brown.
Thank you. So, in terms of what Lon Richardson has indicated, I think that there are, in sections 2 through to 9 of the bill as it stands, essentially what I'd regard as quite an uncontroversial presentation of what the law already is, and that is just very much enshrining in a statutory forum what is generally well understood to be the case. I don't necessarily think that it's necessarily clarifying anything, but it is definitely spelling everything out all in one place. Where we begin to run into bother, in my view, is with clause 10, which I'm reading as a essential codification of the decision that was reached in Countess of Dunmore against Alexander from about 1830, in which you have an issue in which an offer and a withdrawal of that offer, or an acceptance and the withdrawal of that acceptance, arrive at the same time, with the requisite question of being, well, what effect does this have on the relationship between the parties? And the thing about that decision is, as I say, this section appeals to codify it. That decision is not really very well regarded, and I don't think that anyone could make a serious plausible argument that it would be followed today, unless the exact fact pattern were to recrudesce. Because as Professor McQueen himself has indicated in his writing, the basis of the decision isn't actually entirely clear, as other commentators, such as I think Gerhard Lube, indicated. The decision is one which is not very satisfactory, and it is one which T.B. Smith indicated was explained really very much on the basis of its very special and very particular facts. And so I think that insofar as legislating general principles is concerned, there can be a utility to that, as there is in sections 2 through to 9. But in 10, that would involve bringing in and solidifying what I think is quite a controversial rule. Now, the bigger concern that I have, of course, is more to do with Section 13 and what's associated with Section 14, precisely because of what Lorna Richardson and Professor McQueen have indicated previously, and that is this fact that it's quite easy for people to get hung up on the postal acceptance rule as an exceptional rule connected with His Majesty's Postal Service, and anything that is not about giving mail into the hand of His Majesty's Postal Service is distinct, and so it shouldn't be applied, and so on, and that can lead to controversy. But the issue that I really raise, I think, is given quite practical effect when one considers the issue that Bill Kidd indicated earlier in the session about when, I believe it was the AMS service went out, Microsoft is not able to facilitate the exchange of messages, and therefore the whole world comes crashing down. This pointedly gives rise to an issue in respect of Section 13, subsection 3, because it says notification reaches a person when it is made available to the person in such circumstances as make it reasonable to expect the person to be able to obtain access. Well, for one thing, if AMS is down, notification does not occur, as a matter of fact. So you run into a real issue there, and that issue is compounded by the fact that the person who attempts to send notification may be under the misapprehension that the message was in fact sent. We have to trust these facilitators to actually do the job that they're there to do, and it's worth indicating. I know that Mr. Scott Wortley at Edinburgh University, for instance, has taken issue with the postal acceptance rule because, as he says, in the 19th century, the postal service ran multiple deliveries in big cities every day. It was not snail mail as we understand it now. It was very much an integrated system in which messages were not conveyed instantaneously, of course, but conveyed really very quickly. And this takes me to the point that in, I believe it was Thompson against James, the court are flabbergasted that a letter could get posted and not be delivered. They're talking about it as being an utterly exceptional occurrence. And maybe we today wouldn't see it as necessarily exceptional that a letter is delayed or takes time to be delivered or doesn't appear at all. But I certainly think today we would regard it as quite exceptional if you sent a message on WhatsApp that it wouldn't go through, if you sent a message via email and it wouldn't go through. And that gives us an issue with Section 13, subsection 3. Reasonable to who? And that takes me to the point that I understand if you look narrowly at the postal acceptance rule as being a particular doctrine concerned with the post, as many people have looked at it, then spelling out, oh, well, we're getting rid of this, it's an archaic rule, it doesn't make sense, chuck it out. That is defensible from that perspective. But in a bill such as this, which is really seeking to clarify when an agreement is going to be held to have been reached. Well, for one thing, if the bill's doing its job right, Section 14 becomes redundant because it should explain what effect posting a letter has just as much as it explains what effect sending an email will have. But more than that, I think Section 13, in a sense that hasn't fully been appreciated, in a sense which in construction contracts and in complex contracts simply doesn't matter at all because, as Dr Patrick has indicated, most people will just contract out of these provisions anyway. But the default rules are going to be changed, I believe, quite considerably by Section 13 if we are going to say that the notification actually unquestionably does need to take place. And that means that the common law's ability to develop with reference to the broader law of obligations is stymied. And in Cawdor against Cawdor, for instance, in 2007, a case concerned with unilateral promise, Lord President Hamilton indicated that the question of whether or not a promise has in fact been communicated and received to the other party is an adminicle of evidence. It's going to very much help the party who wants to rely on the promise if they can show that it was delivered to them. But it's no more than that. Communication not being necessary to engage. And so that takes me to what I'll sum up as a final point here. Really, what we're dealing with in the situation in which one party has made an offer to another at a distance, expecting the other to reply not in person, not verbally, but by way of some messaging service, what you have there is a policy question about who is to bear the risk of something going wrong with the messenger platform or with the delivery platform. And the postal acceptance rule is there. It's based on what I believe the Lord Chancellor in Dunlop against Higgins said is essentially the common sense principle. There you see it again. Courts can talk about common sense, legislation can't. But the common sense principle that someone who puts a message in the post or to update it for the present day, someone who sends a text message or an email can't really be held at fault for the service provider failing to do what they've done. And so in terms of the allocation of risk, it seems to me to make sense that as a matter of the default rules, whether they are contracted out of or not, as a matter of default rules, the person who says, I want to hear if you agree to these terms or not, I want you to signify that you are going to agree to this or not, to be the one under the risk of the other party accepting. Because the principle, as it stands just now, and the principle that would be retained by the bill, is that the person who makes an offer can withdraw the offer at any time prior to acceptance. And so if we are to move to a position in which actual notification is required, and that is statutorily set out, what we end up with is a position in which the person who makes the offer literally holds all of the cards. And I don't necessarily think that that is the fair position to wind up in.
Thank you. And Professor Bogle.
So Jonathan's given quite a sophisticated analysis there, which is workable. So, and we benefit from Jonathan taking us through that, but that would, if we left today and accepted what Jonathan's proposing here, we would leave today potentially keeping the postal acceptance rule, which would be quite a startling outcome for me, because if you look at the Vienna Sales Convention, which the UN treaty on the international sale of goods, things are either sold via using English law internationally goods, or they're sold using the CISG, the Convention on the International Sale of Goods. And Clause 10 is what's in the Vienna Sales Convention. But the Vienna Sales Convention does not have a postal acceptance rule. So if you look at, and it's just clear. So absolutely, in a sense, I share Jonathan's respect for the heritage and prestige of earlier decisions and where we've come to in Scots law. And Jonathan is given a good explanation of some of the reasoning there. That worked in the 19th century, and we should be proud of that history. It kind of worked before email, and we should be proud that we managed to contain a common law system that was able to get through that. But now in 2025, and we are now, with the benefit of a Scottish Parliament, we've now got the benefit of the Delegated Powers and Law Reform Committee, we've got the benefit of an exceptionally well done and thorough Scottish Law Commission project, and we've got all that at our grasp in 2025. And now we can do legislation that is modern and is contemporary and keeps up with international standards in terms of expectations of parties when it comes to default rules. So we may be leaving behind a heritage in some way, but we also continue it by allowing our system of contract law in Scotland to thrive. And I think legislation is the best way for us to do that in the 21st century. So I disagree with Jonathan, but I admire his respect for the heritage of Scots common law.
Thank you. And Dr. Patrick.
Probably just reiterating a number of the things I said at the outset. If I had been asked to give a formal legal opinion on a number of the, as I am often enough, a number of the issues here, I would have written down quite a lot of the stuff that is in the bill, because it sort of reflects what we sort of think quite a lot of the law is. There are a number of aspects where there are specific changes because there are specific problems or specific updatings required for this background. And one of these is obviously the postal rule. And I completely agree that there's a risk allocation here, but I just think the current risk allocation is wrong. And that the back to Professor McQueen's playground argument, what would people predict the answer for this to be? Are you going to be surprised if you discover that this didn't come through, and lo and behold, I'm now bound by this when I have acted on this offer not appearing at such and such a point. So that's, I suspect, probably all I have to add to the point. We're picking off specific things and we're clarifying specific things to make life more, the results more predictable, I suppose, for people in normal circumstances.
Okay, no, thank you for that. So certainly, we heard in the last session the question regarding the scope of the bill, because the bill is quite limited. And also the written submissions are quite clear in terms of your considerations. But I think it certainly would be useful, certainly just for the public record, with regards to your thoughts and views with regards to the limitation of the bill. Should the bill actually should it be broader, or should there be a kind of different approach taken with regards to the wider contract? I'll start with Dr. Christie.
Thank you. I mean, in the bill, it consciously excludes issues which are very relevant in construction contracts. In particular, issues around Battle of the Forms aren't dealt with in the bill, and there is discussions in the Law Commission's work around liquidated damages. And I'm of the view that that is correct, that they should stay out of the bill. I think the general trend in the case law is away from creating little bodies of rules within contract law. So the rules are in battle of the forms, I think, again, are something that maybe when some of us were at university a while ago and some of us maybe were still at school. But anyway, a few years ago, those would be a little chapter in the book. Here's the law around the battle of the forms. I think the general trend in the case law is to try and simplify the law of contract around a clearer assessment of the party's intention in a particular situation. And in my submission, I put a reference to recent in-house decision in Caledonian Water Alliance, which was a battle of the forms case, but actually the court went down to a more fundamental idea of did the parties agree a contract and what were the terms of that contract. So we don't need to have a separate body of rules around battle of the forms on that analysis. Things like liquidated damages, I think, speak to an interesting feature when we look at the common law development in the UK as a whole. The sort of areas which you might want to legislate on are areas of controversy, and they're areas of controversy across the UK, and we then have the benefit of recent UK Supreme Court decisions on them because they are the things the UK Supreme Court are taking up. So there is relatively recent case law on liquidated damages in MacDessie, which the Law Commission have considered, and that has seemed to prove a workable solution. We have recent-ish, it feels recent when you have to teach it and then you realise it was 10 years ago. You have recent case law on interpretation of contracts, which again seems to be providing a reasonable basis for moving forward, so you wouldn't necessarily want to run against that trend. We do see very recently, last week, a decision where the Supreme Court distinguished the law of Scotland, or at least said that something which had been treated as the law of England wasn't the law of England, but it remains the law of Scotland. So there are areas of difference. I think those come down maybe to questions of underlying values of contract law, which are very interesting, but maybe not for today. But I think in terms of the general scope is let's fix the things that we need to fix, but let the law continue to develop where it is developing. And I think that's a sensible way forward.
Thank you. And Professor Brown.
Yes, not yet, unfortunately, just Doctor. But I think I'm in complete agreement with what Dr Christie, the newly minted Dr Christie, in fact, has just said there. But I would say that my view is echoed by him. Let's fix what needs fixing. I am not actually convinced that what this bill is trying to do is fixing anything that needs fixing, because I do think that, as I say, the law is already clear as it stands until you get to particularly sections 13 and 14, at which point you're making a policy decision where different views can and will be taken. But that is not necessarily a problem with the law. That is a matter of politics, really. So I would suppose I'll leave that to you.
Okay, thank you. And Professor Bogle.
You can just call me Stephen. That's what my kids call me. But I appreciate it. Thank you. So I completely agree with David's point, like particularly going through the recent case law. So I don't have much to add there. I think if I can talk about the strategy, I think the strategy is sensible. We've got the execution and counterparties stuff. What is it? 2012. Then we've got third parties legislation, and now we've got this, and doing it in this piece. I don't want to say piecemeal way, but a strategic way allows us to look at every individual reform in a clear way and just build up slowly. And potentially, yeah, in 20 years' time, there may be more. But I would agree with what David says about the decision on the individual bill, but overall, what we're doing is sensible.
Okay, thank you. And Lorna Richardson.
The comments already made, the bill is Professor McQueen indicated there's a shortage of time for some of these matters, and so we should be sensible and make most use of the time that we have with fixing where there are problems. And in relation to other areas that were looked at by the Law Commission in their discussion papers and the report, there are and have been some issues in other areas, but they have been, with one exception, being developed appropriately by the court. So it's a targeted bill looking at particular issues and seeks to do that in a way that's, as Stephen's indicated, targeting issues is something that's become sort of familiar to the work of the Law Commission.
Thank you. And Dr Patrick.
I'm in favour of the word incremental rather than piecemeal.
Yes.
Law Society submission did indicate, obviously, there were various other pieces or increments that might be added as far as interpretation, battle of the forms, remedies, etc. But I'm equally with Professor McQueen's. You'll never get there with it all. Best is enemy of good, etc., etc., etc. These other fires are not burning quite as brightly. I don't think we may come on to some of them. The courts will solve some of them. So not yet, but we will be doubtless back for other increments at some other point in the future. Okay.
Can I clarify something?
Sure.
My kids call me Dad.
So, I'm not calling you Dad.
What I did mean to say was my students call me Stephen, but I think that shows you how much I care about my students, that I misspoke and called them my children. So, I mean, you get...
Indeed. No, thank you. Can I come back to Dr. Patrick just for a moment? When you touched upon your the Law Society submission, and also used the word incremental. With the bill that we have in front of us, does the Law Society consider that the only dealing with certain remedies for breach of contract in the bill could lead to fragmentation and legal uncertainty long term?
Well, I suspect not to a great degree, rather as, again, Professor McQueen indicated, these are relatively discrete areas that are being looked at. You start creeping into well, for example, buying off retention claims with damages, for example. Is that a mixing of remedies? But I think overall, I don't think it is a problem. It's fragmented in the sense that it's not all that part of it is sitting there in the common law and part of it is sitting there in this legislation as fallbacks. I don't think it is an issue we need to get overly concerned about.
Okay, no, thank you. Bill Kidd.
Thank you very much. I don't really have a great deal to ask now because you've covered such a vast area there actually between you all, which is great because that's why we're here. Could I ask though, because Battle of the Forums raised a wee bit of an issue there at one point, do you think that section 2.2 of the bill could provide a solution to the current problems in contractual negotiations which are actually caused by the Battle of the Forums? So section 2.2, would that help us get over that, hopefully? Or maybe I've asked something that nobody knows. I think Jonathan's going to...
Yeah, well, I think I'm sceptical, as you might say. I'm a bit of an outlier here between the five giving evidence today. I'm sceptical of the legislation, and my immediate view, it might not surprise you to hear, is I don't necessarily think that it could, but more importantly, I think my answer would be a much more firm. I really don't think that it should or should try to, because I think that the point, as raised by Professor McQueen earlier in his evidence, is a good one, and that is the Lady Carmichael, in her judgment, essentially solved most of the issues. And as Dr. Christie has indicated, the more recent Caledonian Water case, again, shows that kind of trajectory, shows that what might have been perceived to be a problem at one time really isn't now, but more pertinently, that has been solved by virtue of the fact that, as I indicated earlier, the courts can solve problems as they come up using common sense. Legislation can't do that because by its very nature it is general, it's not dealing with the particular situation. And so I think this kind of situation is best left now to common sense to deal with, because common sense in this, if nothing else, does appear to be prevailing.
Okay, thank you. I think Dr. Patrick wanted to say something there.
Well, I don't know. It's an interesting one. Yeah, we'll run both the standard terms through AI and a comparison tool, and we'll see which ones are common to them all. And I suspect that's almost what the courts were doing to come to these sensible result. And what do you do with the ones that have been thrown out and say, well, it says this and this completely contrary to this here? Is this something that falls within 4 triggering 3? You know, and yes, I suppose my view is that you could argue using subsection, you could apply subsection 2 to the Battle of the Forms, rather than something specific about who wins the Battle of the Forms. But I think, as others have said, that's kind of the way the courts are going anyway in the Battle of the Forms. So whether it's in or not, we probably end up with a not dissimilar result.
Would it be useful, and I ask this on the basis that you all are involved in educational side of the law and all that, would it be useful to train students in such elements, even if it doesn't actually resolve everything as Section 2.2, just to sort of give them a guidance and a general idea as to where to look? I don't know, that's just going off at a tangent, but I thought it might be interesting.
I don't necessarily think so, again, because I think one of the main things that I've kind of put across in my submission was that in terms of education, when you're dealing with a subject like Scots private law, not merely contracts within the broader framework of Scots private law, it's much more useful to look at the points that are general and have implications and effects far beyond the very narrow situation that you're dealing with. For instance, this afternoon I'm meant to be teaching an aspect of the law of trusts. Trusts are typically formed in many cases by contracts, and of course if you're dealing with succession, for instance, a last will and testament is dealt with via the creation of a written document. Both these sorts of contracts and testaments, general contracts, whether for the sale of land or anything else, they have certain formalities that need to be observed in respect of the requirements of Right in Scotland Act 1995. But more than that, there are general principles that apply, as Professor McQueen very eloquently puts it, along with Professor Thompson in his book on contract. If you're dealing with the creation of an instrument of this kind, you can't be doing something impossible or illegal or trifling. All of these features come up again and again and again in private law. So I actually think it would be, from a pedagogical standpoint, quite harmful to say, and then we take contract and we remove it from the fabric of these general principles of private law, and we have in Section 2.2 the rule that relates to the formation of contracts, and only the formation of contracts, and forget about trusts, forget about promises, forget about succession, forget about everything else. I think that would be unhelpful. And more than that, in terms of certainly how I was taught the Battle of the Forms, I remember it stuck in my head, so it must have been quite useful. The solution to that could either be taken, if you're looking at the offer acceptance analysis, the winner is whoever fired the last shot, because you're operating on the basis of, well, they sent their acceptance last, and so you've operated on the basis that a contract was formed, and so we can treat you as that. But the other one is, as I say, the much more pragmatic solution that is reached of, well, you are acting as though you are in agreement, therefore we can construct an agreement out of what you can be reasonably taken to have agreed to.
That's helpful, thank you. Lorna, I think you wanted to say something.
Yeah, I teach contract law to undergraduates, and I teach them that it's an agreement that's intended to have legal effect. I teach them Section 2. I don't tell them it's Section 2 because it's not Section 2 yet, but that is the common law of contract, that parties enter into an agreement which they intend to have legal effect. And so offer and acceptance is one way that we use to identify whether the parties have reached that agreement. But this is not restating the law in a way that's controversial to my mind. This is setting out what the law currently is. In relation to the Battle of the Forms, it has been an offer and acceptance analysis that has to date predominated, not the more recent cases, but certainly the idea that the court is saying there has to be a contract. There has been performance of a contract, so we can't say that it's happened for some other reason, it must be on the basis of the contract. And so the last short rule has predominated in the Scottish cases, the idea that if you get your terms over last, the other party, by performing, sending the goods or performing the service, has accepted by their conduct. So we are looking at not just what the parties are sending to each other, but how the parties are acting, because contracts, yes, can be by express terms, but can also be inferred from the parties' actions. One other point, sorry.
No, carry on.
One other point is the Scottish courts can use common sense to an extent, but we are bound by a system of precedent in Scots law, and I think that's important to bear in mind, that it's not just each case comes up and the judge can just decide, well, this seems more sensible in this situation. Courts are bound, judges are bound by prior decisions that have been made and decisions that are higher up the judicial hierarchy. And if we have some decisions that are troublesome, that are difficult, that are contrary to the expectations of people using the law of contract, whether they realise they're using the law of contract or not, I think that's when we have an opportunity to step in. And whilst people might have queries about whether the law is sufficiently clear when it's set out in a bill, it doesn't deal with particular eventualities, I do think we can and should do something with this opportunity to make sure we don't have rules that people are shocked by in Scots law, and that we undo or move forward and move beyond those type of rules that would cause someone some genuine confusion or genuine shock to realise that that was the legal rule that was applying.
Okay, well, you had a lot of nodding going on there, so thank you very much indeed for that. Thank you. Oh, sorry, David. Yeah.
Quickly, I think one of the things about some of these things is it relies on a metaphor which is maybe outdated. So Battle of the Forms, last shot, I think that's a 20th century approach to warfare. And I think, as Hamish has said, the way that parties contract nowadays is much more asymmetric. And I think it's appropriate this piece of legislation helps to move us past what is an old metaphor.
Okay, thank you. Well, thank you very much, everybody. Thank you. Yeah.
Yeah, thank you. And Ross McCall.
Thank you, Convener. Hello, everyone. I'm looking for general comments, please, and I'm not bothered who I should start, but general comments on the Bill's rule on remedies for breach of contract. Who would like to go first? No one. Lorna, thank you.
In relation to this part of the bill, I think it is making more changes, whereas in the earlier part there are some changes but otherwise clarificatory points. But these changes are necessary. In relation to mutuality, we have a number of cases in Scotland which have indicated that if you are in breach of contract, you cannot sue on the contract. And that, I think, really that causes windfall benefits depending on if you see that party A breaches the contract and the consequence is £100 and party B breaches the contract, the consequence is £1,000. The person who breaches and causes a loss of £1,000 gets a gain there by the other party not being able to sue, and so that does create some difficulties. And so what's proposed, I think, in section 17 is to make clear that you can, notwithstanding the fact that you've breached the contract, that doesn't mean that you're out of the contract, that you can still rely upon the contract and can sue upon the contract. So I think that provides clarification in relation to a line of cases that have perhaps taken us down a wrong route in Scots law, and does create some difficulty in practice. In relation to other aspects, return of benefits received, that's something that is drawing upon the work of the draft common frame of reference, as Professor McQueen indicated. There seemed to be a difficulty where there's the unreciprocated performance from the other party, and some rules to try to deal with that. We have some cases that are at a fairly low level at first instance, indicating that this is part of the law of contract, but it has been a matter of some doubt for some time. So moving the law in the direction of saying that this is a remedy, and that this remedy doesn't sit in enrichment, it sits in the law of contract. Okay. And finally, the final issue in relation to remedies, as the bill is currently drafted, in relation to contributory negligence, I think it's a very clear clarificatory point. It's caused quite a lot of difficulty, and there doesn't really seem to be any controversy about saying if there's a breach of contract, regardless of whether or not it's also a delict or a breach of a statutory duty, then contributory negligence can be taken into account. The one thing that's missing but has been alluded to in terms of forthcoming amendments is retention, and I think that there are a number of problems with the law of retention as it's currently understood. Professor McQueen indicated that very shortly after the Scottish Law Commission had looked at that part of the law of remedies in producing the report, that the Inner House then issued a judgment that, quite frankly, raised more questions than it answered, and so instead of having set up the courts to move things forward, as we've seen in interpretation, as we've seen in liquidated damages or penalty clauses, it's taken a turn that's less desirable, and so this would give us an opportunity to deal with some of the difficulties there in a remedy that actually is very practically useful. So that would be something that I would be supportive of going forward, that would be taken into account.
Thank you very much, Lorna. And I think the law of retention and those amendments are going to be. I think that's another line of questioning that might be coming up a little bit later on. Has anyone got anything else they want to add on top of Lorna's very comprehensive submission there regarding the breach of contract? Is there any additional points to be made?
I agree with Lorna.
That's fine.
Part of the confusion that has been coming up has been in connection with, well, why these remedies and only these remedies. And I think that in the main, a lot of the remedies that are being dealt with, they cross into judicial remedies, but there's an element of self-help about them. But there's also, as Lorna has indicated, the connection with the law of unjustified enrichment that is at play here. And that is where, again, one of my concerns with the bill as it stands comes up, being a bill that is about contract and sequestering contract from the broader Scots law of obligations. I'm concerned that this bill might continue to lead Scots practitioners down the wrong path of thinking about contractual remedies as having a degree of primacy, where really from the 1990s onwards, with the unjustified enrichment revolution, the law of unjustified enrichment could be prayed in aid of in a broader range of circumstances. I'm not as absolutely set on that as in respect of some of the other views I've expressed, but that's just an immediate concern that I have. And in connection with that is the observation that Dr. Patrick made in his written submission about the amount of time that was available for submissions in respect of this bill to be put in, combined with the fact that there's talk of amendments at stage 2. I'm quite concerned that such an important area of the law is perhaps being dealt with in a bit more of a slapdash manner than it should be, given its importance.
Okay, thank you. Yes, thank you, Stephen.
I think the Scottish Law Commission considered these remedies, consulted on them widely. As it's been explained in 2018, the Inner House made a decision on retention that made things considerably unclear, which then meant a lot of the research of the Scottish Law Commission was then pertinent to the amendment that's been proposed. I think this is about agility. I don't think this is about being slapdash at all. I think it's seizing a moment that we have to clarify the law. And in a way, like, I know we're coming on to this, so I'll stop, but it certainly seems to me a really sensible way of proceeding.
Okay.
And I was only bothered about the retention one last minute because I sort of thought, what's this? Obviously, the Commission report's been there for ages, and otherwise, I'm pretty much in agreement with Lorna Richardson. Clearly, there are various subtleties around it. You know, if the remedy for rescission is kind of restitutionary, we're sticking people back where they were before. Well, for a lot of contracts, that's not the answer, and the legislation kind of tries to do something about it, but it can't do everything for them for everything for it. But what is proposed, and we'll come on to that, does more than it helps. And otherwise, people contract out and say, "Well, we're 5 years into this contract, and you've got a hospital off me now. What are we going to do about it now since you've rescinded the contract?" Well, we better take the hospital to bits. But there's a contract that says what happens in that circumstance.
I understand. Sorry, Lorna, I think you want to come back in.
I don't think it's fair to say that the reforms would be slapdash if they're brought in, given the work of the Law Commission, the consultation process that was undertaken then, also the consultation that was undertaken last year by the Scottish Government, both in relation to the draft bill and then in relation to retention itself. So yes, it's been a fairly short consultation period in relation to the bill after its introduction, but that is preceded by quite a bit of consultation and discussion prior to that.
Okay, thank you.
Slapdash is definitely too strong a term, but it was said essentially not so much as a criticism of the work of the Law Commission or indeed the Parliament, but more in connection with, I think, the reality of the situation, which is that although these consultations may take place, I think there is a general sense, given how busy absolutely everyone is, whether in academia or in practice, that a lot of folk will not engage with this sort of process unless it seems to have a degree of immediacy, unless it seems to be, oh, right, no, they're going ahead with this.
Okay.
So my concern is, for all that there has been a lengthy period, perhaps not everyone who may have had views. I mean, it's quite clear I came in at a very, very late stage in the day, and especially in respect of my submissions here. I missed the boat on the call last year because I was too busy writing a book about exactly this subject. So I'm not saying everyone's in that same position, but there are others. So yeah, it's not a criticism. Slapdash is not the correct word to use there. So.
Understood. Sorry, David, if you've got anything else to add at all, just before I move on to the next question.
No, but Lorna's paper on retention is excellent, and I think as a foundation for the reform is actually, builds on the Law Commission's work really well. So I think that, again, and I think Jonathan is regretting slapdash, but I think let's add that into the mix as not being slapdash.
Yeah, understand. Thank you. So what's your view of arguments made in response to the call for views that guidance will be needed on the legislation? For example, on how the new rules interact with areas of contract law which remain governed by common law. And again, I'll just work my way along, Lorna, if I can start with you.
It's the bill is not a new code. It slots fairly uncontroversial rules, I would suggest, into the current common law. So the common law will continue to operate around this. Sure. And that's very clear from the drafting of the bill. I would suggest you using terms and concepts that are familiar to contract lawyers. So I think lawyers are sometimes a bit reticent to change, and there's something new and we have to see how it works. But I don't think this bill is particularly problematic, and that it's something new, it's something to get to grips with, but it's something that is designed to sit with the existing law. So almost like there's been a new case, how does it fit into the existing law? You would need to do the work and understand it, but I don't think it's especially problematic.
Okay, thank you. David?
I think the drafting, it's quite a wordy bill, but I think that's because it's trying to do something a bit different from most legislation. Most legislation is either looking to solve a problem or tell people what they should or shouldn't do. Yeah. This is actually setting up the conditions in which things happen legally, and I think in order to capture the variety of things that it's doing, it needs to do what it needs to do. So I've been trying to think about how could you simplify, and I don't think you can. I think you have to go with this level of complexity because it's doing, which I think Professor McQueen said, it's trying to capture common sense, and maybe it's trying to capture what common sense was in an era when you didn't have to always spell that out. There was codes of understanding, sort of high context, low context communications. In a world where people don't necessarily have the same understanding, it needs to spell out those things in a bit more detail, and that's what it does. But that's just the way it is because of what the bill is trying to do.
Okay, thank you. Jonathan?
I think that in respect of what Lorna said in connection with a lot of the bill, is kind of, in a sense, it can be treated almost as if a new case. I think that was a good way of putting it. But one of the issues that I'd come back to again is this idea of section 13, subsection 3, because reasonable is one of those words that lawyers love. But more than that, in terms of the context of that, I come back to the point of reasonable to who. Yeah. That is something that, if that word needs to be retained, then the guidance would absolutely have to spell out, because what is reasonable to one party is not always what is reasonable to the other, and what is reasonable to both parties might not be what is reasonable from the perspective of a judge or decision maker.
Okay, thank you. Stephen? Nothing more to add?
I don't think there is guidance necessarily needed because
Okay.
it's the job of a solicitor to update themselves on developments.
Right. Okay, that makes perfect sense.
And I'm not much either. They don't read much guidance. I'm not sure I agree on the reasonable either. That's what the solicitors and courts are for. I'm not even sure I agree that it's wordy.
Okay.
I draft lots of stuff that's far wordier than this.
As I'm watching the dissent
Yes, it's a
from the
model of
panel.
clarity, in fact.
Thank you very much indeed for your answers. Okay, thank you, Convener.
Thank you very much. And Katie Clark.
Thank you. And what is your view on whether the new rules on contract law should only apply to contracts entered in after the bill comes into force? Shall we just go around the table?
I think that makes perfect sense. It gives people an opportunity to get up to speed with what the changes are. It means that when you have entered into a contract, you have done it on the basis of the law as it was at the time you entered into the contract and with the understandings that went along with that. So to my mind, it makes sense that the provisions of the bill would only apply in relation to contracts entered into after the bill, if it's passed, comes into force.
Absolutely, and that's not unusual.
No.
You know, you always have that with contract law reform, basically. So it's not. It might feel a bit weird, but there is always a transitional phase.
It comes back to the point that Dr. Patrick raised at the very beginning. Party autonomy is the lodestar of this area, and so the parties entering into an agreement entered into it on the basis of what the law was. If that is to change, it can't change retroactively because that would have a serious effect on their autonomy. So I think that, yeah, it should only apply prospectively.
Yeah, from the point of view of the rule of law, it needs to apply after.
Okay.
There are changes. So
Okay. Good. So you've already given some views about the Scottish Government's proposals to amend the law of retention at stage 2. Are there any additional points that you'd like to make in relation to that? I'll come to Lorna because I know.
That I'm supportive of the change, and the reasons for that have been alluded to by Professor McQueen and in some of the discussions by the panel members today, that since the Law Commission made its proposals, there have been significant developments, and I would suggest that they've not been welcome developments in relation to the law of retention. And so with this bill looking at remedies, there is an opportunity to deal with something that's causing quite a bit of practical difficulty. Retention operates in some respects as a self-help remedy, and it should be clear if people aren't going to court. No, it should be clear if people are going to court, but it should be especially clear if people aren't going to court when they can use a particular remedy. And so I think we have an opportunity in the passage of this bill to deal with some of the problems that have arisen.
Yeah, I think with my construction hat on, I think it's a very important remedy for those residential construction cases because it provides a self-help remedy for both parties, with the contractor to have some security for payment and for the occupier who's procuring the work to have some security, you know, that the work will get done. The key there is that it doesn't go too far and isn't used frivolously or in terms of the safeguards set out in the legislation. So there's a balance between safeguards and usability, because the more safeguards you have, the more complex it becomes and the more difficult it then becomes for these people to use it. And so I think it's important when you have this remedy that everyone knows what it's for and why they're trying to do it. But I think that the balance set out now is appropriate. I think in my papers I had a slight panic about substantial completion, which is the current safeguard for many construction cases, but I think that's picked up with the way that the legislation is working in the not clearly disproportionate. Thank you.
Any further points? Or?
I just come back on the contracting out again, and that it's otherwise predictable in most circumstances. I would also suggest that while people talk about it as a remedy, it's actually quite a bit more substantive than a remedy. And this is concerned me slightly in the context of when the Scottish courts might apply it to an English or a New York contract or something like that. You've got a Scottish energy company, bank, whatever, entering into into a swap with a New York bank under New York law. They're suing them in Scotland. What's your remedy? Oh, your remedy is retention. Is it? Oh, is that a remedy? The Scottish courts must apply it because it's a remedy. They'll apply New York law or whatever is to the rest of it. But in actual fact, retention is in many respects also a very substantive thing. In a lot of these situations, it won't matter because the party autonomy means that they've written it out in such copious detail that the court, because you can contract out of it, will then be able to say, well, this is what the parties agreed should happen.
I suppose my concern is to come back on the point of, again, emphasising not slapdash, not saying the work done was slapdash, but it's more just coming down to what concerns I have about essentially the parliamentary life remaining. There aren't all that many days of Parliament left until the election come next year and so on. So it's not so much my concern with the intellectual work that's been done as much as the appropriateness of bringing something like this in to a bill at stage 2, because I know that, again, I'm the outlier in saying that I think there are controversial aspects to this bill. But I've got concerns about doing things on the basis that's proposed.
Can I just add, I think it's rare that you get an opportunity like this to make such a meaningful and yet uncontroversial change to the law at the same time. And the opportunity is here right now. And Lorna's research over the last 10 years has identified the problems that the courts have had, which is controlling the self-help element of this. And the suggestion that Lorna's made in her work about proportionality, just sitting everyone down and saying, was that a proportionate response to that breach? That's what the courts have been trying to do, and we've got a great opportunity here. And although the amendment has been issued, it's issued because of developments in the court, and we've got the opportunity now, and Lorna's done the work. The Scottish Government's consulted last year, so this is good, provided the caveat that Hamish has mentioned, that we ensure that clause 21A is taken as part of part 2, so parties can contract out of it, just to make that clear.
Thank you. And Lorna, do you think there should be a right to contract out of any rules on the law of retention?
I do. Yep. It's this whole idea that parties voluntarily enter into contracts, and to a large extent we let them contract about what they want and how they want to, and that would just follow on. So I would agree that there would need to be a change to the opening wording to part 2 to make clear that the amended sections are also default rules and can be contracted out of.
Okay. So anybody that has any further on that particular issue?
Well, not quite that, but just in terms of the role of the committee and the place in the parliamentary opportunity, I think this is one where, the language around disproportionate, which is there, what are the safeguards? Are the safeguards things that people can understand? Well, the committee are people. Do they understand them? If those make sense to the committee, then that is a decent way of wording the safeguard, taking account of the need to retain flexibility. There may be slightly different places and ways you can draw that line, but that's why it's useful to be subject to parliamentary scrutiny rather than just having us as a bunch of experts coming and say, yeah, it must be that. So I think there's a benefit in this process to consider the precise wording used, but obviously I think we all stand behind the scholarship that has led to the bill to where it is today.
And are there any other comments that you'd want to put on the record in relation to the bill as drafting, or indeed any of the arguments made in the responses to the committee's call for views, perhaps points that haven't been made already in this morning's evidence session?
I just think the committee should be commended for considering this, because it fits square within the remit of what we should be doing, if I can say so. So thank you for considering it this morning.
Thank you very much. Thank you.
Good. Does anyone else have any further questions? Okay. I've got one for Dr. Brown. It's a question that's not so much focused about this bill per se, but also between this bill and also the bill that we looked at previously, which was withdrawn, the leases automatic continuation. So obviously your considerations were very much obviously not supportive of either bill. I'm just interested to try and understand, in terms of the process that is followed by the SLC, do you think the SLC are actually looking at correct areas of law to try to be improved or updated, or is it some other aspect?
I think that they absolutely are looking at correct areas, but I fully appreciate what Professor McQueen was saying earlier about, particularly in this area where there was an attempted UK-wide codification project very soon after the two law commissions were created. That would have absolutely had a psychological effect. My concern is not with what they're looking at in this case as much as with some of the conclusions and the approach, because it has taken a very, very long time to get this bill here, and I do appreciate the fact that the commissioners have limited time. But what I would say is, in the 70s, the commissions did produce a very comprehensive code which wasn't simply a transplantation of English law that would have adopted or superseded Scots. It took really the best elements of Scots law, it combined them with some of the best elements of English law. It didn't go anywhere in the end, because when you were dealing with that kind of cross-border situation, it's an inescapable fact that Scots and English lawyers are very often talking completely different languages from one another, even when they're using the same words. And so my concern is that when this bill is concerned, it could have been much more ambitious. I get what prompted what became the bill, looking at the postal acceptance rule, saying this is archaic, it's outdated, and then from there moving to say, well, let's maybe have a statutory restatement of what the rules of formation of contract are. But I think that is problematic because of its limited ambition when you're dealing with Scots private law, which is unlike the law of a purely common law system, one which has been developed much more rationally, and one which does intersect in ways that other jurisdictions don't. And so Scotland does have quite a unique legal system, particularly where the formation of voluntary obligations are concerned. We are quite unique in continuing to recognise unilateral promise as being binding. This is saved in this bill as it stands, of course. But I think that any kind of legislative project, of course, there can be situations in which fixing piecemeal problems like the law of retention as they emerge, that is a useful role for piecemeal legislation, I think. But a statutory statement of a very, very narrow aspect of the broader law of obligations, I don't think is useful. So what I would say is, if there is a need to solve a problem, legislation, a targeted problem, legislation can, even in very piecemeal form, be very, very useful. But if it is about something of more general principle, then legislation can actually have a detrimental effect on the overall coherence of the law. And I think, indeed, Part 2 of the bill, which deals with the kind of interaction between contractual remedies and remedies of unjustified enrichment, but subsumes them under the heading of a contract bill, that's indicative of this kind of intellectual problem.
Okay, no, well, certainly thank you very much for that. And with that, as there are no further questions, I'd like to thank you all for your very helpful and insightful evidence this morning. And also the committee may follow up in writing in due course afterwards. So once again, thank you very much, and that now concludes the public part of the meeting. I'll move the committee into private.